that right there is a violation of my constitutional rights. I have the rights to see that. The UCC does not pertain to any of your rules or your regulations or any of that.
All right, this is the District Court of Comanche County, Kansas, case number 25 CV1. All right, this is the District Court of Comanche County, Kansas, case number 25 CV1. Case is entitled American Ag Credit PCA versus Timothy Peterson, individually and as trustee of the Timothy Charles Peterson Trust, and Shelley Peterson, individually as trustee of the Shelley Peterson Trust et al. We are set today for hearing on the plaintiff's motion for summary judgment. Plaintiff is appearing through its attorney, Nicholas Grillo. And I believe we have for CNH Industrial, is it Quan Nguyen? Is that right?
Yes.
Your Honor, we need to make a correction to the record before we get started.
You just finish introducing the case and then we'll take up any issues.
You bet.
And then also appearing, we have Timothy Peterson and Shelley Peterson appearing pro se. All right. So as I stated, we're set for hearing on the motion. So Mr. Peterson, you believe there's some issues we need to address first?
Yeah, I've got a couple three, Your Honor. Before we begin with my introduction, are we in a constitutional court of record?
I'm not sure I know what you mean.
Are we in the public record?
Yes.
Okay. So therefore, this court is a constitutional court of record. Then would you agree?
Well, it exists under the Constitution of the state of Kansas, so I suppose that's correct.
Okay. All right. Thank you, Your Honor. And we are here sui juris, not pro se. And then underneath the UCC 1-308, we reserve our rights under common law without prejudice. And no, Your Honor, we are not the defendants listed upon this court case. We are living souls and living bodies as living people upon the land, and as the sole executors and beneficiaries to the trust listed as the defendants in this case before the court. We are non-corporate citizens. We are U.S. nationals here in peace and non-combative in this constitutional court of record. And we appear only as a special divine appearance to settle the business matters before the court only. And also, Your Honor, as you have addressed, this is a trust issue. The defendants listed here today, so that was one of the corrections that we needed to have made that hadn't been previously read into the record. Before we begin, Your Honor, do you have proof of your constitutional oath of office to the people? And do you have proof of your oath of service? Because we require you to be in your oath of the Constitution to the people of service and to your oath of office here today.
Okay. Yes.
Okay. And would we be able to get copies of those? They didn't have that, nor your judicial bond copy at the Comanche County Courthouse.
They should. Those were circulated, but I can make sure those are provided to the clerk so you can access them.
Thank you very much, Your Honor. In addition to that, as we are now clearly in the jurisdiction of common law and underneath the Constitution itself, which is the supreme law, are you able to uphold your oath to the Constitution, Your Honor?
Yeah, so I've executed my oath, and that's of the record, so I don't know that that's immediately needed to be addressed today. So we do need to get on with the time that the issue that we're set for, which is the motion for summary judgment. So are there any other specific issues before we proceed with that, Mr. Peterson?
As this is our private, I would like to know, as these are the defendants, if you can see there, Your Honor, these are the defendants, which is our birth certificates, and also they are our minor estate trusts. Does anybody here present today have a higher claim to these trusts and these birth certificates than we do?
Okay, so we're not going to continue with this line of questioning because it's not relevant to the summary judgment motion. So I think with that, I'm going to foreclose any additional quote unquote preliminary matters, and I'm going to turn it over to Mr. Grillo for any argument on his summary judgment motion. So with that, Mr. Grillo, whenever you're ready, if you have any additional argument, you may do so.
Yes, Your Honor. I appreciate the time and effort, the court allowing us to appear via Zoom. Appreciate the accommodation. For the most part, the response, the motion and memorandum in support, as well as the reply, set forth most of the arguments that American Ag Credit would be proffering today in detail. I think that the main thing that I want to point out to the court, and although I'm sure the court's aware of it, in a preliminary matter, we had a motion for judgment on the pleadings, and Your Honor ruled on that on June 2nd of 2025 and identified specific issues that remained in the case that were needed to be decided based upon further proceedings. One had to do with whether or not payments or whether there was consideration for not just the original note in August of 2019, but also the renewals that were executed by the Petersons in 2020, 2021, 2022, and 2023, as well as whether or not there was any proof that said that the Petersons have paid American Ag Credit in terms of that in terms of its note and mortgage and security agreement. And Exhibit 6 to the memorandum of support, American Ag Credit produced a verified payment history, or essentially loan accounting for the line of credit the Petersons took out in August of 2019. That detail in Exhibit 6 shows all the loan advances that were made, as well as all of the payments that were received by American Ag Credit from the time of the inception of the line of credit in August of 2019 through the non-renewal of the line of credit effective on August 1 of 2024. And I think that shows the detail to the court that payments were made not just from the Petersons to American Ag Credit, but also that loan advances were made to the Petersons throughout the life of the line of credit. And it would be American Ag Credit's contention that shows adequate consideration for not just the original note, but also the subsequent renewals, as well as reflects the lack of payment that was received from the Petersons on American Ag Credit's line of credit. So in other words, it specifically addresses the two remaining issues that the court identified and shows that that everything was supported by consideration and that payment hasn't been made. More importantly, there was no contention in response to Exhibit 6, or no affidavit or other material piece of information or facts that were presented by the Petersons in the response to American Ag Credit's motion for summary judgment that shows that there's a dispute in terms of that payment history.
Yeah, objection, Your Honor. They received several negotiable instruments to pay that account in full, and they accepted them, never did return any of those. And by acceptance, therefore, that discharges the liability. My paperworks are complete with that and has evidence of that.
You'll have an opportunity to make your own argument here in a second. So if you'll let Mr. Grillo finish, then I will give you an opportunity.
Thank you.
Well, not in regarding to that, none of that information was presented in response to the motion for summary judgment. No proof was put forth, and I'm very confident that if Your Honor would review that negotiable instrument that Mr. Peterson refers to, it's not legitimate. It attempts to draw on some sort of Social Security trust on the Treasury of the United States to pay American Ag Credit the balance of its loan in full. And there's no consideration. There was no money that was going to be paid. It's just not a legitimate argument or payment. And so, but more to the point, in terms of the procedural aspect of this case, none of that was presented in their response to the motion for summary judgment. There's no dispute that American Ag Credit maintained a note, mortgage, and security agreement against the assets the Petersons owned. There's no dispute that the loan hasn't been paid, or no proof of a legitimate dispute that that loan hasn't been paid, and that American Ag Credit is entitled to a judgment foreclosing its mortgage and security interests in the Petersons' property. As a matter of fact, American Ag Credit set forth 41 statements of uncontroverted fact, and not a single fact was responded to, not only in the appropriate fashion required by the Supreme Court, but in general. There was nothing in the responses the Petersons filed that shows that any of those specific facts were in dispute. But even then, it's not the court's job to, ferret out those items in the record, which is why the rule is the way it has been implemented. And the Petersons were well aware of that rule because they faced the same issue in response to CNHI's motion for summary judgment. So this wasn't a new concept to them, at least in this particular case. And so, Your Honor, I don't see there's any dispute of material fact that exists. I think American Ag Credit is entitled to judgment. There are no affirmative defenses, and there are no issues as it regards to the remaining two items that the court had identified in its ruling, that American Ag Credit is entitled to judgment on those issues.
All right. Thank you, Mr. Grillo. All right, Mr. and Mrs. Peterson.
Now, they did receive these payments that we sent them, and they were not returned, Your Honor. They're writing in their rules and regulations, evidently, that do not apply to the Uniform Commercial Code on negotiable instruments. So their payment was secured. There was no reason to go any further than that. Marbury versus Madison was very clear in its decisions, and that rules, statutories, rulings of even yourself, Your Honor, do not apply to the people. These apply to corporations and to non-legal, non-living entities, dead entities, if you will, Your Honor. They do not apply to us here today. But upon that note, and the word note, we do demand presentation of the original note at this time. We've been asking for the note and has been denied time after time from these gentlemen. It needs to be the original note. It must have the original endorsements, the wedding seals. It must have all allonges or any allonge that is attached to it. And if it does not act in their possession, any of these notes, then they have lost the rights to the note. And the note and security follow each other. So at this time, photocopies are not admissible in a court of law. They cannot be used because you could be tried 3 or 4 times for having the same photocopy when in fact they don't have the original. And only the original, and we demand that to be presented at this time, can be honored, Your Honor. Do you, gentlemen, have the original notes?
Mr. Peterson, we are well beyond any discovery demands at this stage in the proceeding.
Sir.
So I'm not ordering that they're going to be required to produce any additional documents.
Oh, sir. That right there is a violation of my constitutional rights. I have the rights to see that. The UCC does not pertain to any of your rules or your regulations or any of that. It is underneath the common law. Common law states that I have my rights underneath the Constitution, and I am not here underneath the rules and the regulations and the statutory codes of, if anything, in that type of line. I'm here today to get my rights and demands to see that note. If you are trying to subvert the law or correct the law in some unknown manner that has not been presented to us here today, then that, Your Honor, gives me the right to take that up as a liability against yourself and the gentleman presenting that today. I do have the rights to see those notes. Those notes need to be presented today. I've given them ample time several times, Your Honor, and they accepted that.
Okay. And again, I am denying that request and not ordering that be produced.
And at that time, Your Honor, can I then object and that you, Your Honor, and the officers of this courts have entered into rights violations underneath the U.S. 18-242 deprivation of rights underneath the color of law? May I enter that into the record, please?
Well, I mean, you just stated it, so I don't need to make a finding. Okay. So, Mr. Nguyen, anything from CNH Industrial?
No, Your Honor.
All right. Mr. Grillo, anything else from you?
Your Honor, the only thing that I would mention is the declaration that Ms. Bailey submitted, verified under penalty of perjury, that American Ag Credit was in possession of the original note, and that it was the holder of that note, number one, and number two, the same Uniform Commercial Code that Mr. Peterson is citing, which is statutory law, not common law.
True.
Indicates that there's a presumption that unless the signature is contested, that they have signed the note and that they are bound by the terms of it. And there's been no contestation under the Uniform Commercial Code or otherwise that Mr. Peterson and Ms. Peterson didn't sign that, the note that American Ag Credit maintains. And so therefore the presumption is, as a matter of law, that American Ag Credit has the note signed by the Petersons. And so I think that forecloses any issues that Mr. Peterson raised in his comments.
All right. Mr. Peterson, anything else?
Yeah, that remains in the reverse of what he just said. It's wide open. If there remains a note, if it has not been negotiated away by the four banks or whoever they have, then it must be presented. And statutes and codes in the Uniform Commercial Code are actually in place to protect the people from the judges and from the lawyers and such. They are not to be applied to the people. Therefore, I can quote those. And also I can demand those of those people, such as Hinkle Law and Folston Law, and as American Ag Credit, and as CNHI, to present those. If they have already negotiated away those notes, then they've already been paid twice, once by me because the notes were my credit from the start, and the second time through negotiation. If they cannot prove that they have the original note, then they have no honor and no ability to keep asking for additional payments, Your Honor.
All right. I appreciate everyone's argument today. I will take the matter under advisement and issue a written order, much as I did with the same one. So I will review everything that has been submitted of record, both in written filing and here today, and get a written order just as soon as I can. So again, I thank you all for everyone's time. Anything else we need to address before we adjourn?
Your Honor, I don't want to belabor this any more than I need to, but there was at least one other matter that was set on the court's docket today, and it had to do with the Petersons' motion for jurisdictional challenge and a stay pending their attempted appeal on CNH's motion for summary judgment. And specifically, I had filed on American Ag Credit's behalf a motion for additional time to respond to that motion, which was one of the things that was on the court's docket today. The motion was filed by the Petersons on December 4th, which made under Rule 133B the deadline to file a response. December 11th, we filed a motion for additional time on the 10th, asking until December 19th to submit a response, given the gravity of that motion that the Petersons filed. We went ahead and filed our response. So we set this for hearing since there had been no order granting that extension to make sure that that extension was granted and that our response to the motion for stay and jurisdictional challenge it was appropriate.
All right. I have reviewed that motion, and I don't see any reason, and I think there was an objection lodged, but upon reviewing that, I don't think there was any reason that you shouldn't receive the extension. So I will expressly grant the motion for the extension and find that it was timely as filed. So I will take the merits of it into consideration.
Thank you, Your Honor.
And I guess it's probably appropriate, since we went ahead and had argument today, just to rule on the merits of the request for the stay, and the court's going to summarily deny that and will proceed with the summary judgment motion.
Your Honor, I have one more thing before the court.
Okay.
Timothy and Shelley are here peacefully and non-combatively to accept these charges in case CM 2025-000001 on behalf of the minor state trusts, the all capital Timothy Charles Peterson and the all capital Shelley Renee Peterson, that are listed as defendants upon case CM 2025-001, and that are unable to speak as they are legal fictions and creation only. Timothy and Shelley speak for these minor state trusts and living souls with living bodies who have accepted through fiduciary acceptance the right to speak for the defendants and accept, present, and settle all matters before the court in case CM 2025-000001 and in all matters. As Hinkle Law and Associates apparently lacking understanding the law, Timothy asks that you are addressing the debtor as secured party and secured party creditor, and not as the third party intervener in this matter, the property. We are asking for, we accept all of the bonds that need to be brought before us for the damages that have occurred to us, and we ask for them to be certified, and we asked for them to be claimed by me and held, and then we will turn it over to the court to settle, discharge, or dismiss all charges, and before the matters before the court in honor, Your Honor.
Well, I don't know that any of that changes the procedural posture or any of the arguments for the court's consideration. So I believe I have what I need. Mr. Grillo, just to confirm, were there any other